your other matter, Mr. Williams, that also involved a controlled substance, it shows here was November of '08. Are you still on probation on that case?
No, sir.
Okay, and that case was in front of me or Judge Robbins?
In front of you, sir.
That's what I thought. Okay, and it's been closed out?
Yes, sir.
Oh, good for you. All right. And then I can work this. And likewise, your matter gets reduced to just a simple possession, no intent to deliver, but as well, you will be subjected to your analysis. Are you working now, Mr. Williams, since we last saw each other?
When I last saw you, I had 2 jobs, and that was March. I haven't been working since March.
All right. You gonna be clean when they test you?
Yes, sir.
All right.
No, sir.
Well, not today. You gonna be clean come the day of sentencing, though.
Yes,
So
sir.
that's right. That's right. Or you gonna miss more than just Thanksgiving and Christmas. Okay, let's see what we can do, fellas. Right hands, please. Face me. You swear or affirm that the testimony you are about to give to the matters now pending before this court shall be the truth. Except you guys, Mr. Richardson,
Yes, sir.
Mr. James,
Yes, sir.
Mr. Seahorn, Mr. Williams. Hands down. Fellas, you have the right to take your cases to trial. Everyone does, either in front of a judge or a jury, and as to all charges and as to all possible penalties. As you heard, all of you are getting some reduction in charge some way, somehow. Also, you're being spared jail or prison time. Now, you are innocent. You are presumed innocent at a trial, and you remain that way unless the people can prove you guilty beyond a reasonable doubt. You always have the right to remain silent, and the more important right you have is the right to have a good lawyer and to have your attorney negotiate a settlement or represent you at trial. We've discussed our settlements, and everyone has signed on the dotted line. Mr. Richardson, with your form that's before us, understanding your plea deal, this is the settlement you're accepting today.
Yes, sir.
And likewise, Mr. James,
Yes, sir.
Mr. Seahorn, and once again, Mr. Williams. And now the court is satisfied with the proper waivers of the right to trial. People, begin with Darnell Richardson. Start me off.
It was approximately 3:15 on October 9th, 2009 at 12611 Avondale in the city of Detroit in the county of Wayne.
Oh, the old Stark School. All right, at the date and time stated, Mr. Richardson, did you, along with an Antonio Turner, have the opportunity to attempt a break or entering of the old Stark School without permission?
Yes, sir.
And was the intent to break into this school was to larceny, to take something that didn't belong to you?
Yes, sir.
So, sir, to your one charge reduced to the lesser offense of just an attempted B&E of a building with intent to larceny, how do you plead? I'll accept the plea to the reduced charge of the attempted B&E. We have an agreement to withdraw the habitual second and likewise to allow a probationary sentence, just 10 days on the workforce and by statute restitution to be determined. With that, people in defense will be satisfied as to Mr. Richardson.
The people are satisfied.
Defense is satisfied.
Very good. People, date, time, and place as to Andre James, please.
As to Mr. James, it was approximately 6 p.m. on October 9th, 2009 at Chrysler in Wellington in the city of Detroit in the county of Wayne.
Oh yeah, right along the service drive. Mr. James, the date and time stated, were you detained by a city Detroit police officer and found to have in your possession or control a small baggie containing approximately 18 Ziplocs of suspected marijuana?
Yes, Your Honor.
And sir, was some of these smaller Ziplocs intended to be sold or shared or used by other people?
No, Your Honor.
All of this was for your personal consumption?
Hey, actually, I didn't have that. Yes, Your Honor.
Okay, all right, I'm just kidding. I mean, that's a lot here. I mean,
That's a long time.
okay, it says 2 sandwich baggies, total of 43 small Ziplocs, one carrying 18, the other carrying 25. And some of this was going to at least be used, shared, smoked by somebody else.
Yes, Your Honor.
All right, very good. All right. So, sir, to the one charge reduced to the lesser offense of just the attempted possession with the intent to either deliver or share some marijuana. How do you plead? I'll accept the plea to the reduced charge of the attempted P-wit of marijuana. We have an agreement for probation, 5 days on the workforce, and your analysis. I guess pending a bond discussion, people in defense will be satisfied.
People are satisfied.
Good. And in position number 3, I have young Mr. Seahorn. People.
As to Mr. Seahorn, it was approximately 5 p.m. on October 12th, 2009 at 6818 Covert in the city of Detroit in the county of Wayne.
Right. Yeah, Mr. Seahorn, sir, the date and time stated likewise were you detained at this address and found to have in your possession a very small amount of a controlled substance, clearly less than 25 grams, that suspected controlled substance being commonly known as heroin. So, sir, to the one charge of just simple possession of a controlled substance less than 25 grams, heroin, without any intent to sell or deliver, how do you plead? I'll accept the plea to the amended charge of just simple possession. We also have an agreement to dismiss count 2, the P-wit of cocaine, and to allow young Mr. Seahorn a probationary sentence, 15 days on the workforce. He will finish his secondary education. He will be urine tested beginning with the first day of probation. People in defense will be satisfied.
People are satisfied.
And lastly, again, as to Mr. Ronald Williams, people.
As to Mr. Williams, it was approximately 5:35 p.m. on October 9th, 2009 at Chandler in Oakland in the city of Detroit and the county of Wayne.
You're over here on the east side, not far from the liquor store, sir. Were you detained by a police officer and found to have in your possession a couple 3 Ziplocs of suspected rock or crack cocaine?
Yes, sir.
So, sir, to the one charge of just a simple possession of cocaine, again, without any intent to sell or deliver, how do you plead?
Yes.
I'll accept the plea to the reduced charge of just simple possession less than 25 grams. We have an agreement to, 1, withdraw the VCSA violation of the Controlled Substance Act, 2nd, and allow a probation with just 15 days on the workforce. And of course, if his other probation is closed out, he won't have any double dip. People in defense, are we satisfied?
People are satisfied.
All right, very good. And now Miss Lukai, is she still here? She is in our outreach data bit after we resolve the rest. Okay, Mr. Richardson, where do you live, please?
475 Navajo?
Okay, they still have an old address here on Deacon. You don't live in the Southwest Detroit anymore?
No.
So you moved over here to the east side on Navajo? Where?
475.
475. So are you across Jefferson? All right. How long have you been at the Navajo address?
For like 5-6 months.
Okay. The Deacon address was still on your ID, though?
Yes.
Okay, very good. He's out on bond. What's my return date for Mr. Richardson?
December 14th.
December 14th. Mr. Proman, how are you looking for the 14th?
14th looks great.
Okay, good. December 14th
Thank
it
you,
is.
Judge.
Sir, have a seat. Keep your eye on my deputies. They're going to call you up with your paperwork when we get you over to the probation department.